And that would include whether or not the president was entitled, apart from the Audi that he got, and that too is common cause, whether there was an obligation to separately alert him of the possible remedial action to be taken. And linked to that, which is the fourth issue, is the lawfulness of the remedial action itself, because that is the point that is taken. So those are and then the issue of costs. Those are the broad issues about which we would like to persuade the court that the North Gauteng High Court, in setting aside the report and the findings that are identified therein, was wrong. And what this court must determine is whether the public protector, having conducted the investigation the way she did what a reasonable person in her position or circumstances would have done. Not whether the decisions she made were correct or is what we would expect or we wanted, but whether what she did was rational. Therefore, the issues that we must look at, Chief Justice and Justices of the Court, is whether, if one looks at the constitution of the country, and I'm starting with the issue of jurisdiction, if one has regard to both the Constitution, Section 181, subsection 2, and Section 182, and the Public Protector Act, Section 6 thereof, subsection 4A, the finding that the public protector lacked jurisdiction is, in our submission, incorrect. And we start with the Constitution because there is an emphasis, if one looks at the answer since the High Court from the President, there's an emphasis on the functions which are called additional functions that are found in the Public Protector Act. We say those functions that are set out and the obligation to investigate, those are additional. They do not replace what the Constitution identifies or provides as the functions of the public protector. Section 181 is important because as a starting point, it provides for the Office of the Public Protector as a state institution that is to strengthen democracy. And it provides as follows. It says these institutions are independent and subject only to the Constitution and the law, and they must exercise their powers and perform their functions without fear, favor, or prejudice. Of course, 181 subsection 3 thereof provides that these other organs of state, like the FIC, like the president himself, like the NDPP and the speaker, who all participate here, must support the public protector. More specifically, in relation to jurisdiction, we rely on Section 182 of the Constitution as the starting point because it sets out clearly the scope of the functions of the public protector. I underscore this section because the court found that the PP has no jurisdiction. And it says so for two reasons. And I will deal with that later. It says the issues of the donations of money, millions of rands, into the deputy president, as he then was, are a private matter. Section 182 states as follows, provides as follows, and I quote, "The public protector has the power as regulated by national legislation, A, to investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice. B, to report on that conduct. And C, to take appropriate remedial action." I underline the word state because there's a debate about whether state and government are the same. And the court tells us that we can't widen the scope. We differ with the court on that score because there is a reason why the Constitution uses the word state affairs, because it recognizes that government is an agent of the state. It's not the state. This section goes further, Justices, to provide that the public protector has the additional powers and functions prescribed in the Act itself, which is the Public Protector Act.
Shattering.
It's in your jurisdiction.
Chief Justice, I can hear voices while I'm presenting. I suppose there's a technical error or there is a caucus.
No, Justice Teron will take care of it. Justice Teron, just proceed, Mr. Skakani.
Thank you. And therefore, that section we submit clearly states the parameters of the public protector, and that matters that relate to the deputy president, as he then was, fall within matters of the state. Secondly, Section 96(2)(b) of the Constitution obliges the deputy president, as he then was, to not, and I quote the section that is important here, act in any way that is inconsistent with their office or expose themselves to any situation involving the risk of a conflict between their official responsibilities and private interests, close quote. We underscore that section because that is where one finds the standard to which members of cabinet must be held. And therefore, when the High Court says there is no jurisdiction to investigate donations to a deputy president who seeks to ascend to a position of power within his party so that he can be president of the country, and the court says because public money was not used, and I will refer the court to that specific paragraph of the judgment where the court says because no public funds were involved, therefore it's a private matter. Of course, a private party that bribes me uses private money. I'm not suggesting that it was a bribe. I'm just saying the idea that when private money is used, is involved in exchange with someone who occupies the office or to donate significantly to their function, to their campaign, because private money is used, the public protector cannot reach that, is with respect incorrect in our view, because it would mean the public protector would not be able to investigate matters where private companies seek favor with the members of cabinet or government, any sphere of government. Of course, they would use private money to seek such favor. Clearly, the judgment of the court also adopts a narrow approach to the concept of state affairs. And we therefore argue and submit respectfully that if one looks at state affairs broadly, it would include the conduct of the deputy president seeking to ascend to the position of president of his party and therefore president of the country.
The 10 minutes has expired, Mr. Skakani.
Chief Justice, it's okay. I will expect then that the questions will come in my way, but may I proceed?
Yes, by all means.
The next issue, Chief Justice, that I said is broadly is the issue that is involved in this matter, is whether in the circumstances of this case and the investigation by the public protector, the Audi that was afforded to the president is reasonable. And I say in these circumstances because case law tells us that there is no one size fits all.
Sorry to interrupt you, but before you go on to the question of Audi, can I ask you, about the basis for direct appeal to this court. The only basis advanced, as far as I can see, by the public protector is that this matter is very important. As you're aware, in the UDM, this court said that a direct appeal is not simply available for the asking, that there must be exceptional circumstances. What are the exceptional circumstances in this matter?
Thank you, Justice. I was going to get there at the end, but let me answer it now that it's come so that I get it out of the way. We submit that if one looks at what is involved in the matter, as I said right at the beginning, it is quite exceptional that we're dealing with constitutional functions of our president. And we're also dealing with whether or not an organ of state like the Public Protector, which constitutionally is tasked to strengthen and protect democracy, that the two of these constitutional states are at loggerheads about what is the scope of their function and what is the scope of their accountability, is, in my respectful submission, exceptional in this case. Apart from the fact that it's just constitutional matters, I submit that there is something exceptional about the fact that we're dealing with where to draw the line about these two most important constitutional beings. And there is no other issue, Justice Theron, apart from that makes this matter stand out. That is my answer. Thank you.
Excuse me, Mr. Sakane.
Yes.
On the question of jurisdiction, if you could just go back to that aspect, and in particular, deal with the legal question relating to the public protector's area of competence insofar as investigation of the campaign funds.
Yes. Yes, Justice Mkhwebane, you mean to repeat the point I had made there? I can't, I think you're muted, Justice Mkhwebane.
Sorry, if you could expand on that point, please.
Yes. Justice Mkhwebane, the point we make here is that the starting point about whether or not the public protector could venture into matters that relate to the conduct of the deputy president are to be found in 182, which tells us that he has the power to investigate any conduct in state affairs. She makes that point in the report herself, that the conduct of the deputy president, if one reads this together with section 96 of the Constitution, if one looks at that section and the fact that the issue of the deputy president, and because this is not a party political funding issue, there's been an analysis that it's a party political funding issue. This isn't. This is money given to an individual to compete with his colleagues in his party so that he can win, right? And in our view, that is a significant donation by private parties into the coffers that are designed to advantage a single individual, not a party, to win internally so that he can become president of that party. And as we know, those issues are matters of the state. They may not be matters of government in the narrow sense. We want the court, we submit that the court should have looked at state affairs that the Constitution identifies as to include the conduct that even is in the private sphere.
So the argument is based on the fact that much as he was campaigning as a member of the ANC at the time, the fact that he was the state was his deputy president, she would fall within the jurisdiction. He would then fall. His conduct will fall within the jurisdiction of the public protector.
Absolutely, it's 2 points. It's his own position as deputy president, which is what we submit is covered by Section 96 of the Constitution. That's one part. The other part is the constitutional function provided for in Section 182 about what the public protector can investigate. And we say that the conduct of the deputy president, who's trying to become effectively the president of the country, is a matter within the definition of state affairs. And we submit that the notion that this was a matter that relates to party political funding is dispelled immediately by a statement by the ANC, which says, no, this was not donations into the ANC and how it should advance its own internal democracy. This was a donation to a person with those that were around him to compete and defeat their own colleagues in the party. It was not a donation to the party. May I proceed to the audio?
Mr. Skakane, I'm sorry, Mr. Skakane.
Yes, Justice.
Can I take you back to the issue debated with Justice Taron?
Oh, sorry, Justice Jafta. Yes.
Yes. You mentioned the only factor being that it is an important matter relating to the scope of the powers of both the president as well as the public protector, which justifies a direct appeal. Now, our jurisprudence has laid down a test that says it must be exceptional circumstances, and the cases have listed the factors that would constitute exceptional circumstances ordinarily. And if one looks at those factors, one does not find this factor of the importance of the power and the functionary that is the repository of that power. Now, I just want to understand, how does it square up to the standard laid down by this court in relation to circumstances which ordinarily would constitute exceptional circumstances?
Justice Jafta, my submission on that score is simply that if one looks at the, well, we phrase it as the importance of the matter, but I suggest that it is, I submit that it is exceptional in the sense that you even if it's not important, the nature of the functionary is not important, but we suggest that, as I said earlier, what I call the clash, and I don't mean personally, but I suggest that the clash between the head of state in relation to the extent or the standard to which he must be heard, and how far the public protector can go to deal with the head of state and the nature of his or her accountability. In my submission, in our submission in this case, is a matter this court must consider exceptional. It may not be exceptional all the time that a case between the PP and the president are exceptional. I'm not suggesting that at all. I'm suggesting that if one looks at this matter, it deals with a breach, a possible constitutional breach of the function, which is Section 96. And if we are wrong that it was a breach, we are wrong. But our submission is that it's the matter of a breach by the president, a possible breach of Section 96 of the Constitution, and the deputy president, as he then was, is an exceptional matter.
I'm trying to understand that. I may let you know, perhaps you're aware of it, that we have already dismissed a case where the president was involved on the basis that a direct appeal was not warranted in that matter. And the matter also related to an allegation that the president has breached an obligation that is imposed upon him by the Constitution to sign a bill that has been passed by Parliament and was submitted to him. So I just want to understand, how do you postulate the test and say it has been met here? In other words, when we distinguish this matter from the other matters, what would be the distinguishing factors apart from the fact that it is the president who's involved on the one hand, it is obligations that are imposed by the Constitution on him, it is also the public protector whose powers derive from the Constitution?
Justice Jafta, I understand what Justice Jafta is saying, and I'm aware of the test and the court and the judgment. As I said right at the beginning of this particular question, I am not submitting that each and every case that relates to the two functionaries, that on its own constitutes a exceptional circumstances. I'm not even suggesting that each and every circumstance that relates to them fighting over their functions per se is exceptional. But I'm suggesting that in this matter, and in the circumstances of this case, where the president is accused not just of a breach, but a serious breach and a possible accusation that the president lied to Parliament over and above what his duties are. My submission is that that on its own distinguishes this from any previous or future clashes between the two functionaries. It's the only issue that I think separates this matter from the others. And if I'm wrong on that, I'm wrong on it.
Okay, finally, from my side on the issue, I think the underlying reason for pitching the test at the exceptional circumstances was that the Constitution creates a structure of our courts, and it confers constitutional jurisdiction on the High Court and the Supreme Court of Appeal. So if a litigant wants to bypass the Supreme Court of Appeal, that litigant must justify why the Supreme Court of Appeal should be denied the opportunity of exercising the constitutional power conferred upon it by the Constitution.
Justice Chaff, can I make the last point on this? I hope it will be good enough to enhance the other obviously poor ones I've said, is that this matter, apart from, I submit that this matter hangs on the heads of both the PP and the president of this country. And therefore, I submit that it's in the interest of justice for this court to deal with the matter once and for all. Because for as long as it carries on, it hangs on the heads of two of the most important constitutional functionaries. And I think it's important for this court to determine, in whatever way it determines it, and deal with it once and for all. Thank you, Justice Jeffrey.
Thank you.
Mr. Skakan.
Yes, Justice Madam.
Let me take you back to your state affairs argument.
Yes.
If assume that it was somebody running for the leadership position of one of the opposition parties. Would your argument stand or not?
It would. I'm scared to get to this debate, Justice Madlanga, because lawyers don't want to get into political science, which is the source of all of the law, of the things about how the state governs itself. In this way, I mean, the court tells us that the definition of the state politically does not help. Well, it does, in the sense that one has to look at the state, including government, as, let's call it a place where political players compete, but basically compete in order to capture the state. It means to be part of the ruling elites, either in the local government or any other sphere of government. Therefore, the conduct of a political party in its endeavors to get hold of the levers of the state is a state matter. And therefore, the line that separates what is the conduct that is private for a player in politics is very fine. And I think that is what Section 96 tries to tell us, is that those leaders upon which it calls to exercise caution, it doesn't just deal with how they conduct themselves in their public duties, but it's about how they conduct themselves in their private life, because it is in our parties where we go. It is in the weddings and functions where officials get bribed. They don't get bribed in their offices. So 96 is to guide, alert those in those positions, not just to guard against conduct within the public sphere, but how in their private lives and their private ambitions, they may compromise or run the risk of a conflict of interest between the matters of government and the matters that are private. Justice, if I may complete the part about Audi, because I think it's the part that about which the public protector has been attacked. Chief Justice and Justices, we submit that if one looks at the great lengths to which the public protector went to afford the president opportunities to comment, first, because 7(9) obliges the public protector to alert the implicated person. I wouldn't like to read the entire section, but it obliges her to do so. And in this case, it's common cause and it's not denied that that she did. On many occasions.
Let me come in there, Mr.
Yes,
you accept that what the public protector was to do was a two-stage process. First, is there merit in the complaint? And second, if there is, what should the remedial action be? So it was that two-stage process. I'm sure the answer is yes.
I'll cautiously say yes.
Thank you. Now, let me take you back to the common law.
Yes.
I've always understood the common law to say you are entitled to Audi as long as the applicable statute does not say you are not. That is what the common law was. And on the common law, my understanding is that if there are two distinct stages, you would be entitled to Audi at each one of the two stages. Now, that would mean, in accordance with the common law, an affected individual would be entitled to a hearing even at the stage of the remedial action. You'll comment if you disagree with me even as to what the common law says or said, you will correct me. Now, moving on, I would understand the Constitution to seek to, even make that stronger. That is the administrative justice, to make it stronger. Now, if you say that at the stage of the remedial action, there is no need for another opportunity for a hearing, that to me sounds like a retrograde step, and a retrograde step in the face of a constitution that I would think seeks to even improve the situation. Can you please comment on that?
First, Justice Madlanga, I agree with you, right, that the Constitution must seek a higher standard. Maybe where I don't want to say differ with you is the point I would make is that even with that.
All right, the Constitutional Court there hearing a direct leave to appeal against the full bench judgment and order of the High Court Gauteng Division, Pretoria. You'll remember in March this year, the High Court reviewed and set aside the decision by the Public Protector to investigate and report on the CR17 campaign for the ANC leadership elected in December 2017, and also reviewed and set aside the findings and remedial orders in the Public Protector's report. The Public Protector was also ordered to pay punitive costs in the application. So, some of the questions that are being tackled. Did the president mislead Parliament in relation to the donations made to the CR17 campaign? Also, did the Public Protector have the scope to investigate the CR17 campaign? Advocates Kekane, they're making the argument. We'll try to return you there to the Concord hearings as soon as we can.